We're looking for closure. I think everybody's looking for closure at this point in time.
I have amended the verdict slip. It's the exact same verdict slip, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge?
Because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
The instructions are very confusing. They're confusing for attorneys and they're confusing for the layman who is the members of the jury.
Questions and confusion. Will Karen Reed's jury come to a decision today? We're live in Dedham, counting down to day 4 of deliberations. And is this deja vu from the first trial? Our power panel breaks down what may be holding the jury up, and we take a close look at that verdict form. Plus, no matter what happens to Karen Reed, this case isn't going away. Johnny Depp's attorney is joining us live to talk about Karen Reed's potential civil liability. And also coming up this hour, it's really a battle of the families in some ways. How the O'Keefes and the Reeds and all of the dynamics could be affecting the case. It's all coming up next for you right here on Opening Statements. Good Wednesday morning to you and welcome to Opening Statements. I'm Julie Grant. This is the show I like to call Coffee and Court. We get you all warmed up for the big day ahead on Court TV Live. And oh, what a big day it's going to be. It could be verdict day. So without any further ado, let's start things off as we always do. Grab that cup of coffee. It's time for my opening statement. Will we see round 3? My friends, that is the burning question this morning. As the last question from the jury on Tuesday asked, what happens if they find Karen Reed not guilty on 2 of the counts, but can't decide 1 of the counts? So which one are they stuck on? If I had to bet, I think it's count 2, the manslaughter while operating under the influence. I am sure that everyone involved in this case is hoping that the jury reaches a verdict. And then this criminal chapter of the case can be closed. Then the civil chapter will begin. Remember, no matter what the outcome in criminal court, the O'Keefes have a pending wrongful death civil lawsuit against Karen Reed. So what happens if this jury is deadlocked again? Can you imagine trying the manslaughter charge and this case a 3rd time? Can you imagine how stressful and awful that would be for everybody? Especially the O'Keefes. Remember, they've suffered a death, and they've waited quietly, respectfully, and patiently to get justice for their John. I must say, this was a well-tried case on both sides. I have to hand it to all of the trial attorneys involved. Everyone did their very best. And really, that's all that everybody can hope for. I don't know what the jury's verdict will be, but I do know that whatever it is, we must respect it. And hopefully the O'Keefe family will be shown respect no matter which way this case goes. That's my opening statement. Let me know if you like it. Right now, it's time for your daily docket.
Where are you headed? We're going to
Well, we're coming from WSU.
So you're coming from Washington State University?
Yeah.
And you're going where? Oh.
We're going to be going to Pennsylvania.
Oh, okay.
In Idaho, we've got accused killer Brian Kohberger back in court today for a pretrial hearing. His defense team will argue to try to delay his upcoming murder trial. Court's going to begin at 2:30 p.m. Eastern Time. In New York City, we've got the government's case winding down in Sean Diddy Combs' federal sex trafficking trial. Testimony gets back underway at 9 a.m. Eastern Time. And in Connecticut, we've got the newest trial we are tracking for you. We're calling it the Preppy Party murder trial for defendant Raul Valley. The 20-year-old is accused of fatally stabbing 17-year-old James McGrath back in 2022 outside of a house party. Right now, though, we turn to our top story for you. We're on a verdict watch this morning in the case against defendant Karen Reed. Now, day 4 of deliberations will start up in just about an hour from now. The jury's been deliberating for more than 15 hours now. So what seems to be the holdup? Well, the verdict slip seems to be central to the confusion. Here's part of the form. This is page number number 2. The jury sent out 4 questions on Tuesday, and one of them pertained to the second page. They said, does convicting guilty on a subcharge, for example, offense 2, number 5, convict the overall charge? Judge Beverly Cannoni answered their question by bringing the jury in and going over the form step by step, working it down top to bottom.
If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. That means on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense.
So, are you getting deja vu from the first trial? Is the verdict form the problem? We got an amazing power panel standing by. I want to bring them in now. I've got with me retired FBI Special Agent Jennifer Coffendaffer, criminal defense attorney and former prosecutor Franz Borghardt, and criminal defense attorney and former United States Attorney William Ehlenfeld. Good morning to you all. What do you think is the problem? Let's go around the horn here together. Ladies first, please. Jennifer, would you start us off?
Yes, good morning, everyone. You know, the jury verdict form, this is so interesting to me because I have never seen so many problems regarding a verdict form. I was trying to look back and see any case where this verdict form has risen to this level of confusion, and I haven't. Personally, reading it, I don't think it's that confusing. There's a lot of subparts to it, but it seems pretty easy. Check guilty if you think she's guilty here and not guilty if you think she isn't, and drop down menu from there. But nevertheless, clearly it's confused this jury and the previous jury.
Sure did, Jen. You're right. Franz, you were with us giving analysis in the last trial. Do you feel like this is deja vu again?
I think we are approaching the same issue we've seen already. And my concern is, what is the effect of a hung jury on one count if we don't have clarity? I'm trying to echo Alan Jackson from yesterday. If we don't have clarity on, and look, yesterday it was theoretical. I agree with the judge. We don't have a note saying we have reached a not guilty on 2 counts, we are hung on the other. We don't have that. We have a note that says something differently. So my concern is, we may be in the same boat and looking at a third trial if, in fact, the Commonwealth wants to pursue this a third time.
Right, Franz, that is the major concern. And they have said they will try and try and try until there is a verdict reached. William Ehlenfeld, last but certainly not least, I want you to weigh in on this. Your thoughts, please.
Well, what a day yesterday. For not having a verdict returned, there was a lot that occurred yesterday in that courtroom. And if I were Alan Jackson, I would have stood up and made the same argument that I'm afraid the same thing's going to happen as happened in the first trial. However, I think the judge handled it just perfectly. She has to be careful. She can't answer hypotheticals. She can't put unnecessary pressure on the jury. She can't confuse the jury. And I thought she did a nice job of going over that portion of the verdict form, calling them back in the courtroom, going through it line by line. And I agree with Jennifer. I don't think it's that confusing. And I think we're going to have a verdict today. I think clarity was achieved yesterday with the judge's explanation, and we'll get a verdict sometime, hopefully this morning.
Yes, I think you're right, William. And if you don't mind, I would love a follow-up question to ask of you, please. So along those lines of the judge and what she should say and shouldn't say when these questions come in, there was a lot of confusion with the jury, apparently, when it comes to if they reach a verdict on 2 of the counts. They said if we find not guilty on 2 of them, but if we're stuck on the third charge, what does that mean? Does it mean we're a hung jury altogether? And the judge was not inclined to answer that, not inclined to tell them that you can reach a partial verdict. She declined to answer. William, do you think that was the right call? And if so, tell us why, or why not, please.
I do think it was the right call. Now, the law does permit partial verdicts in Massachusetts and across the country, but the judge is respecting the jury and the process and how delicate it is right now. This is a very important part, the most important part of this case right now, and she doesn't want to do anything to improperly influence this jury. And that was a hypothetical, and it's her practice, and she believes the law to be that you don't answer those types of questions. You send the jury back and encourage them to continue to deliberate. Now, she did leave a little opening to maybe do something more if this drags on and if more questions come through, and you might see her do something else. But I think at the moment yesterday, that was the right thing to do.
All right, William, thank you for that. Franz, tell me, when it comes to the form itself, we know the defense team has challenged it and challenged it. They said it was bad the first time. They're saying it again. This has been a real sticking point for them. Your thoughts on the form overall? Do you think that the judge should have made a different call, especially after last time?
So, one, it's a form. So Massachusetts uses that as a form. So to some degree, I'm not saying that the judge's hands are tied, but many states have standard forms for standard crimes. So that's where we start. Secondly, I think the tactical mistake by the defense was making the formal motion after deliberations had started. By doing that, there's a strong argument that if we change the form now, it may become suggestive to the jury in terms of which way I think you should lean. I think she did the right thing clarifying the form. I think look, guys, this is a very difficult spot to be in as far as the judge's position with using a Massachusetts form. To some degree, if she diverges off the reservation of the form, then someone has a appealable issue. So it's a tough spot for her to be in. But look, in my mind at least, she's clarified it, and it isn't a confusing form. And look, I hope that Massachusetts does something about this after this trial.
Right, Franz. Yeah, they should. You're absolutely right. Jennifer, I want to go to you and get your insight and thoughts on some of the questions that the jury asked. They asked, what is the time frame for the OUI charge at 12:45 a.m. or 5 a.m.? They asked, are video clips of Karen's interviews evidence? How can we consider them? They asked, does convicting guilty on a subcharge, for example, offense 2, number 5, convict the overall charge? And of course, they asked that question about if we find not guilty on 2, but can't agree on 1, is it a hung jury on all 3, or are we hung on just the 1? Jen, thinking about what the jury's process here may be, your thoughts on where they may be stuck, please.
Well, what interesting questions. Normally, when you get these questions that come back from the jury, they don't provide a lot of insight. These provided a lot of insight. And again, we don't know exactly where they're coming from, but it appears to me that they are not stuck on count 1, that appears to be a not guilty, or count 3. It appears to me that they're trying to figure out that time frame, looking at the OUI manslaughter, which I think many agree, and I certainly agree, that charge is most telling in terms of what really happened and what she really is guilty of and what the CW, the Commonwealth, proved. So I think that is the charge they're hung up on, which makes all the sense in the world when you look at that timing issue they're asking about.
All right, Jen, I'm in agreement with you, and I want to get predictions from you all on the other side of this break, so stand by kindly, please. Will the verdict come down today? Well, we'll find out together here on Court TV Live, and we have a very special guest joining us at the bottom of the hour to talk about how this case isn't over yet. You recognize him. You remember him from Johnny Depp's defamation trial.
Has any woman come forward since? This is Me Too without any Me Too.
Brutal murders of 4 University of Idaho students.
Oh my God, this doesn't happen here.
Detectives arrested 28-year-old Brian Kohlberger.
You could tell there was some off about him.
He was stalking them. He was hunting them.
Forget about motive. We don't even have a connection.
This trial will be on Court TV.
And I pray that we have justice.
The Idaho College Student Murders Trial. Live coverage begins this August, only on Court TV.
Does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge?
Not going to be any comments right now, guys. Nothing? Nope.
How do you get through this? Waiting.
No comment means no comment.
If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? It's a theoretical question, and we don't answer theoretical questions.
Mr. Reed, any comment?
Feeling.
Not really. Not really. How are you spending the deliberation time? In prayer, and, that's about it.
Both sides of this case on pins and needles, understandably so, as we get ready for day 4 of deliberations to begin in less than an hour from now. Defendant Karen Reed's fate hanging in the balance. The jury continuing to weigh whether or not she's responsible for the death of her boyfriend, Boston police officer John O'Keefe. And discussion of that verdict form is really at the top of everyone's mind, in particular the charge of manslaughter while operating a motor vehicle under the influence of alcohol. Taking a look closely at that form, these jurors are using this to decide. And a focus of the fourth and final question of the jury on Tuesday had to do with the verdict form. Whether or not they found Karen Reed guilty on, not guilty on 2 of the counts, and they're hung on another count. They wondered what that means for the case overall. So today they go back to deliberate. Tomorrow is a dark day. Court is closed tomorrow for the Juneteenth holiday. So that then means what happens? Do they come back on Friday if they're still deliberating? Would the jury really go into a 4-day break without delivering a verdict if the judge doesn't bring them back on Friday, meaning they would get Thursday, Friday, Saturday, Sunday, come back Monday? Or do we think the time frame might encourage a verdict today? I think so. What about you? Let's bring in our power panel. Still with me, Jennifer Koffendaffer, Franz Borghardt, and William Ehlenfeld. William, you told us in the last segment that you think the verdict's coming today. Tell us why, please.
I do, Julie, and I think you framed it very nicely there with the holiday coming up. And the weekend after that, the jury is very mindful of that. They don't want to come back on Friday or next week. They want to get it done. And, the judge also wants to see this wrapped up. One thing I was thinking about yesterday is if I were Karen Reed and Alan Jackson, I would have been disappointed that the jury went home yesterday and the judge didn't ask them to stay a little bit longer into the evening, because they were right on the verge of coming up with a verdict that I think would have been in her favor. And sometimes when juries go home and they sleep on it, they come back in the morning, they think differently. I've experienced that personally in some of the work I've done where juries have really flipped overnight. I don't think that's going to happen here. I do think they're going to stick with their not guilties on 1 and 3 and come back with a conviction on the operating under the influence on count 2. It's almost unfair, though, for us to be able to make predictions when it's almost like we have the answers to the test, because those questions really clue us in as to where this jury is headed. But I think that's what they're going to do. There's probably a few people that want to see that manslaughter conviction at the top of count 2, but I think ultimately there'll be some sort of a compromise, and they'll come back with a guilty verdict on part 5 of count 2.
Gotcha. Okay, well, that's a good prediction there. Okay, so I think are we all on this panel in agreement that it's count 2 that they're stuck on? It seems to me, Jen, I know you kind of said the Franz. What do you think they're stuck on? Oh, I see you shaking your head. Which one? Which one is it?
I've been doing this for about 20 years, and the one thing I know with certainty is I cannot predict what a jury is doing, even when they ask questions that seem to be bright neon lights. I think it's reasonable to believe that they're stuck on that, but my prediction is they're going to hang on that count, and they're going to, at least the defense will have at least clarity as to what counts they are not hung on, which will at least attach jeopardy. But guys, I'm not comfortable looking at this case and saying this is what they're thinking right now, because we have no clue. This could be one rogue juror. This could be a pack of jurors. We just don't know. The fact that the note referred to her by her first name, maybe that's a Massachusetts thing. Maybe it's not. I don't know. I can't predict what they're doing. So I am uncomfortable. Look, I wish I could agree that it's count 2 that they're haggling over. I just don't know.
If you had to guess, Franz, I'm going to press you. If you had to guess, where do you think the not guilties are? Where do you think the sticking point is?
I think she is out of the woods as to the top charge. That's what I feel like my gut is telling me.
Right.
My issue as to the other not guilty. Look, they could compromise with the lowest OUI charge, which, by the way, Massachusetts has a savage penalty for first offense OUI, up to 2.5 years. I don't think she gets 2.5 years, but who knows? So the only thing I'm comfortable, if you're going to press me, the only thing I'm comfortable with saying is I think she's out of the woods for the top charge, which is a huge win for her. I know she wants to walk completely, but that's a huge win. Whether or not they're haggling over the manslaughter or the lower OUI, I don't know.
Gotcha. No, I hear you, Franz. Jen, last but not least here, certainly with these predictions, what are you thinking they may be stuck about? You know, you said earlier you think it's that count 2 in particular. What do you think the problem may be? And then also, what's your final prediction for them coming back today?
You know, Julie, I never really have gut feelings. I really try to go with what we're seeing and the facts we have before us. If you look at count 3, I think there is an issue with that charge because of the voicemails she leaves. In other words, leaving the scene of an accident resulting in death. I mean, she's screaming at him. She calls him 56 times. I'm not sure this jury is convinced that she thought he was dead. Yes, she hit him, but did she really mean to kill him, and did she leave him for dead? So that's why I think 3 is out. I also think 1 is out because I think this jury just thinks that is too strong of a charge, which is what many people believe. But if you look at count 2, I think they're literally hung up on, can they show from the evidence that she was intoxicated at that time? And they're trying to use that clip of her where she says she was drunk and how much she drank to prove that point so they can have that charge stick. I think that's where they're hung up.
That's really great analysis, Jen. I'm with you. I think it's 1 in 3 that for them, they have noted not guilty. If I had to bet, I would feel comfortable and confident in that. For the reasons you stated, that leaving the scene of an accident resulting in death, you hit the nail on the head, Jen. Her voicemails muddy the waters. Did she know that he was dead? Just when you look at the way the charge is laid out on the verdict, I don't know if we have that 3rd page of it, but just the way the charge is written, I could see where a juror would say, well, wait a minute, we don't know what time the death was. We don't know if she knew right then and there. There it is. See it? Leaving the scene of an accident resulting in death. Was death apparent to her? I can totally see why they would just discount that charge. And so that's why I think it's that manslaughter charge they're stuck on. William, I want to go back to you, please. You were also a state-level prosecutor for many years before becoming the United States Attorney in West Virginia. And when you think about the question about Karen Reed's interviews and how the jury said, Judge, how do we consider them? Are they case evidence? How would you feel if you were on the Commonwealth side and a prosecutor hearing that question come back?
Well, whenever questions came back and I was a prosecutor, it made me nervous. It's such a, you put your heart and your soul into these cases, and then a question comes out and you just, you're sitting there with such great apprehension, wondering what it is that's on their mind. Throughout this trial, I thought that was, Hank Brennan did a great job of introducing those clips from her and showing statements that she's made and inconsistencies and highlighting those. And so, when I first heard they had a question about that, I thought that would be good for the Commonwealth, a good question, a positive question. Listening to Jennifer, though, I can see it in the other direction too. So, but all in all, I thought that was important. It was for Hank Brennan to introduce those clips during the trial. I thought it was a good part of their case. They didn't get to question her on the stand. She didn't testify, so they were able to hear from her and hear some inconsistencies. And so I saw that as a positive for the Commonwealth.
Definitely. Excellent points, William. Okay, so we'll go around our power panel quickly with final predictions as to whether we think this is going to be a verdict whenever it comes today, next week, or if we think we're going to have a hung jury potentially yet again. Franz, I'm going to start with you. I know this is the big fear we all have. Your prediction.
So verdict as to the not guilties, hung as to the other counts.
All right. Jennifer, what do you think, please?
Not guilty 1 and 3, and I think they're going to find her guilty of 2.
William, what do you think? What's your prediction, please?
No hung jury. They don't want a hung jury. They made that clear through the question that they asked. So not guilty on counts 1 and 3, guilty on subpart 5 of count 2.
Great predictions from you all. Boy, I can't wait to see what happens. We will find out together. Jennifer Coffin-Daffer, William Ehlenfeld, and Franz Borghardt, thank you all so much for being so generous with your time and for the excellent insight and analysis. We're going to hit a break. When we come back, we're talking about how no matter what the verdict is or no verdict, the case isn't going away. Why? Because it will enter the civil court system soon. And we have one of the country's best civil lawyers joining us on the show live next. Attorney Ben Chu joins us right after the break. And the O'Keefes and the Reeds, 2 families present every single day throughout every single hearing and date of both trials. We'll talk about the family dynamics with a relationship expert and psychologist. Be right back.
I feel strong, and the jury will do the right thing.
Guilty or not guilty, or hung jury, who knows what the outcome will be. But one thing is for sure, this won't be Karen Reed's last court battle. This morning, we're shining the spotlight on the civil lawsuit that's already been filed against her by the family of John O'Keefe. It's a wrongful death lawsuit. And they're also suing 2 bars in Canton where she and John O'Keefe were drinking the night of his death. The suit is seeking at least $50,000 in damages. But the civil suit was put on hold until after the criminal case was resolved. Now, who better to talk about this with than the lead counsel for Johnny Depp in his defamation trial that we all watch so closely here on Court TV, Attorney Ben Chu. And here he is in action at the trial.
A false allegation can devastate a career, and it can devastate a family. And the evidence will show that Ms. Heard's false allegations had a significant impact on Mr. Depp's family and his ability to work in the profession he loved.
I'm so pleased to have Ben Chu joining me live this morning. Ben, good morning to you. It's wonderful to have you on the program.
Great to be with you, Julie. Thank you for having me.
Oh, thanks so much. Well, you are a marvelous advocate. You know your stuff in the courtroom, and we all enjoyed watching you in action in that case. And you know what it's like to be under the microscope, having the cameras on you, all of the public scrutiny that comes along with a case so high profile. So let's turn to this one here in Boston that I know you've been following, Ben. Starting with the O'Keefe's wrongful death lawsuit, because that's one we definitely know is pending right now. How do you see that one playing out?
Well, as you know, Julie, the standard in a civil lawsuit is far different than the beyond a reasonable doubt standard applicable in the criminal case. So the hurdles that the O'Keefe family will have to overcome are lesser than the prosecution has in the criminal case. So that once the criminal case has been resolved, the stay will be lifted, and then the discovery process will begin.
And in that discovery process, Ben, can we expect the O'Keefes to take Karen Reed's deposition?
Absolutely. And once the criminal case has been resolved, she will not have any Fifth Amendment right not to testify as she exercised completely appropriately in this criminal trial. She won't have that luxury in the civil trial. She will effectively have to testify. And so we will hear from her, and the jury will hear from her in the civil case firsthand.
Ben, thank you for that. That's an important distinction, too. So essentially, help us understand, please, is anything off limits with a deposition that would happen like that in this case?
No, it's, as you know, the standard is very liberal. The plaintiff's counsel can inquire into anything that's reasonably calculated to lead to the discovery of admissible evidence. So that's a very broad standard. They can ask her about virtually anything as long as there's some scintilla of a tie to the case.
Wow. What would you expect they may want to know about? Something that perhaps they weren't allowed to bring into this criminal case that they're going to want to ask her questions about at deposition time, Ben?
Well, they are going to go into the relationship from actually, they're going to start at the beginning, really, of her adult life and go through the whole chronology of the relationship with O'Keefe. They're certainly going to meticulously go through every minute of what happened that night, the drinking at the bars, any history of disputes, and it's going to be a long deposition. In fact, I would anticipate that plaintiff's counsel would ask the court to extend the period for taking a deposition. I could see this deposition taking 3 days easily.
Wow. Wow, Ben. We would love to have you back when the time comes to do some more analysis on it. Tell me, when we think about other possible civil liability that may exist for Karen Read, I want to ask you, please, about something you're certainly familiar with in the analysis you've given us on the case, and that is how the Read defense has tried to put forth a third-party culprit defense, essentially pointing the finger at other people. And we know it's gotten very ugly in the court of public opinion. We know that there is a pending case for harassment and witness intimidation for Karen Read's friend, Turtle Boy, Mr. Aidan Carney. I'm curious, do you think that Karen Read and Mr. Carney could be also exposed to defamation lawsuits?
Well, that's a great question, Julie. And the answer is yes, if they make statements out of court. As you know, there's a real distinction between statements that are made in pleadings, which enjoy quasi-immunity. So you can say make a lot of harsh accusations in pleadings that are not susceptible to defamation cases. However, if you go out and you give interviews or you speak publicly and you make those same statements, you are opening yourself up to potential defamation liability. And by the way, as you know, that includes lawyers. So lawyers sometimes think that they're immune or that they can say anything they want to in public about their clients' cases. That's not true.
I'm so glad you brought that point up, Ben, because we know that there has been a lot said by Karen Read's defense team, and there have been the impromptu press conferences and things outside of the courthouse. I wonder, do you think there should be any concern on the part of anyone on her legal team for anything in the civil court system to be filed?
Yeah, they need to be very careful about that. That's why, I mean, you have to be careful about that for a lot of reasons. We saw in the criminal trial, the jury has just asked about whether they can consider Karen Read's public statements. And that could be a problem for her. Certainly in the civil case, it can be a problem for her. And absolutely, it can be a problem for her attorneys as well. You have to be careful when you're trying to win the battle of public opinion. You have to focus first on your client and your client's potential liability and your own potential liability.
Brilliant analysis from you always, Ben Chu, as we're talking about the O'Keefes and their civil lawsuit. We see them walking toward the courthouse right now, and we know we need to let you get off to court. You have more cases to win. Ben Chu, thank you so much. Looking forward to talking again soon, I hope.
Thank you, Julie.
Take good care. When we come back, we'll talk more about the O'Keefe family and about the Read family. They're there at the courthouse as well. We're talking about the dynamics, and we're bringing in an expert to help us sort through it.
How are you spending the deliberation time? In prayer, and, that's about it.
Mrs. O'Keefe, she lost her son in all of this, and it's sad. It's really sad.
We're getting you ready for the biggest trials across the country before court is in session. Plus, deeper dives into true crime stories with our daily spotlight.
Opening statements with Julie Grant. Mornings at 8, 7 Central on Court TV.
It's the biggest story that we're covering. He is the boogeyman.
So many eyes have been on Donna Adelson from the beginning. A social media sensation, now a suspected killer.
Welcome back. A lot of discussion surrounding defendant Karen Reed's retrial has been focused on her relationship with victim John O'Keefe. But it could be the family dynamics within the case that tip the scales.
Mr. Reed, any comment?
Not really. Not really.
How are you spending the deliberation time?
In prayer, and, that's about it.
Mr. Reed, your family looked visibly relieved. There was like an exasperation moment when you found out the question.
Yes.
Do you feel the jury's leaning a certain way?
Well, you make inferences to the best you can, but you never know what anybody's thinking.
Are you prepared for a verdict?
Inside the courtroom.
I'm prepared to hopefully find our daughter free.
That was Bill Reed, the defendant's father, speaking to Court TV on Tuesday. Here are some members of John O'Keefe's family entering the courthouse this morning, wearing blue to show their support for him. Both families have been visible in the courtroom throughout the trial and every hearing that happened pre-trial. The defendant's parents seated right behind her in every hearing, and there is the defendant, and she is wearing blue today, which is an interesting choice because she has told her supporters to wear pink, and we see them wearing pink, and we know the O'Keefes have worn blue to show support for John. So that is interesting today, seeing that. Let's talk about the family support, though. Let's talk about how it could potentially sway the jury, because the jury's looking at both families. They see the O'Keefes, they see the Reeds, they see everybody. Let's talk about that. Let's bring in psychology expert who's a nationally known expert in the area of parenting and family relationships. She's also an author, Dr. Sue Kornblue, standing by with us. Dr. Sue, good morning. Always great to have you on the program. So,
good morning, Julie. It's great to be with you.
Oh, thanks. So tell me, we know the jurors are seeing the families. They're very aware of who everybody is in the courtroom. How do you think the families in the courtroom may impact the jury or not?
That's a great question. Now, I've been watching this, as you know, daily, but I'm looking at something completely different than other people are. I'm looking at their emotional reactions because of what I do. Look, I think they could have an influence on the jury, but probably not as much as people think. The O'Keefes, I mean, you can look over, you can see the pain in the mother of what has happened here and, how devastating this has been for her. This isn't the first time she's going through this. And it's grueling to keep having to hear this over and over and over. It's a trauma. And this has been going on way before they got into the courtroom. And now this is the second time. She also knew Karen. So there's all these mixed feelings, I think, going on here in terms of what has happened here with the family. Now, you can look at Karen's father. He's suffering too. We saw that yesterday. So the one thing that I think both sides here have in common, Julie, is fear and anxiety. And it's coming off to the jury. But the jury's not there to base their decisions on how the emotions are coming across, although it can have some influence. They're here to base this on facts.
Right, Dr. Sue. Interesting, hearing you talk about how when you watch people, you look for emotional reactions. And as you know, there's been a lot of people, and Karen Reed herself has talked about how she's scrutinized and the way that she looks, and people read into things. You're an expert in this area, so I'm curious what you see, when you look at her in the courtroom when there are these big moments, perhaps, let's say, for example, moments where we're looking at autopsy photos or moments where, you know, John's injuries are being described, things like that, and we haven't seen her crying in the courtroom. Is there anything to be noted from that?
Well, look, not everybody's going to cry in the courtroom. She needs to present as very confident. The things that I see that are troubling on a psychological level are her emotions sometimes don't meet what is happening. She will smirk a lot. She will smile a lot. It can come off as very cocky. And that is not a good way to present yourself in court. This is a serious, serious issue that is going on here. And I think it is, you need to present as very stoic, listening, not smiling or laughing. It's condescending at times. And I think that can throw off the jury, too.
Sure. How about the O'Keeffes, Dr. Sue? Looking at them, we know that there were moments where we saw Peggy O'Keeffe getting very emotional on the stand, understandably so. We've seen her get emotional in the jury box. What effect, if any, do you think that has on the members of the jury?
Well, I think, you know, they can see or have empathy for her. This is a mother that lost her son. So if there's any mothers on that jury, they can relate to that and how horrific that would be. I think her tears came across as, you know, very genuine and authentic, and I'm sure that they are. You know, Julie, it really depends, right? Who's on the jury and how they emotionally react and see these witnesses, parents, brothers, sisters. That's what we're really looking at here if we're going to look at how the jurors emotionally react to this. Everybody reacts differently, analyzes emotions differently, and that's where I think it's very difficult to be on a jury, because one jurist could think, oh, totally guilty. And I'm going to vote this way because of the emotional reactions by the family members. But another member could say, no way, they're faking it. So it's so complicated when it comes to the family dynamics, watching this and being on a jury. And for me, it all comes down to what I said, the fear factor. Both families are in fear here. The O'Keeffes are in fear that she won't be convicted, okay? And the Reeds are in fear that she will be convicted and what is going to happen there. Every day, these family members are walking in the court with fear and anxiety of what is going to come. And it's grueling and it's draining.
Right. Doctor, so we only have a little bit of time left, but quickly, does it mean anything to you that we don't see these families interacting at all? And we don't see Karen interacting with the O'Keeffes? What, if anything, does that tell you?
It tells me that there's probably been too much bad blood between the two at this point, and that they're keeping their distance for a very good reason, because emotions are high, and if things are said in jest, who knows what could happen. So I think it's a good idea that they're sitting separately. But you know, Julie, they're both in pain. So isn't that interesting in different ways?
That is something that sadly they have in common. Dr. Sue, you're wonderful. Thank you so much for the great insight and analysis. We'll be right back at the Courthouse Live.